All right, good evening. Welcome and good evening, everyone. Want to welcome everybody to the Discipline Matrix Ad Hoc Committee, Wednesday, February 5th. We are starting at 6:07. Apologies for a little bit of the delay. Wanted to get on the same page with our panel and our folks here tonight. Captain Hubbard, Deacon Lyles, welcome. I believe Marsha Peterson, Past Chair Peterson is actually, she's going to be joining us, I think, a little later. And yeah, so to get started for this evening, we want to do a little bit of a recap of where we've been. And the last meeting we made, we continue to make significant progress and covered all kinds of things from real good discussion around patterns of conduct, supervisory accountability, the supervisory notes. We had a really good discussion, continuing to talk about that. What else? The vision system improvements. We discussed that, policy review. And I think, as we look at some of this stuff, we had talked about wanting to also take a step back and look at the amount of work we've covered so far, where we at as we continue to take out big chunks, and then where we want to continue to head. And so as we do that, I know for some of our next steps, Captain Hubbard, we wanted to incorporate some of the feedback regarding the patterns discussion that we had. And there were a number of other things that we had put a pin in, particularly around the Class 1 and Class 2 violations and those fruitful discussions that we were having around possibly establishing those classifications for certain manual rule violations. So with that, I will hand it to you. And as we were discussing prior to us starting the meeting, I think it would be a good time for us as a group and the public for us to recap where we're at and kind of maybe take a step back and see where we're headed, and have a discussion around that as well too, as we know it's a lengthy process to continue to move this along, and we want to just kind of do a little quick temperature check on that.
Sure.
So
yeah, thank you for that. This has been on my bucket list, I think, since October, but I was able to kind of consolidate all of my notes that I've taken for all of our meetings. And I was encouraged by this long list. And I'm sorry, I can't make the screen bigger because I have a different app that I'm using for this, but these are all the sections that we actually covered. And it's not bad. Some of them, I think, maybe we glossed over a little bit too quickly, and we can certainly come back to it, but we certainly did look at them, and we made a lot of great strides. So my notes here are not completely done, but does give us an idea of where we came from. Just starting at the top, if you remember, we did talk about the oath of office. We came up with our own preamble, our mission statement, visions, values, and also a summary of everything that kind of encompasses those mission, vision, and values. And then we started knocking out a lot of these sections, and we covered all of these in really great detail. Those in red that you see here, these are new sections that we came up with. And I have them here. But I do have to still import some of my notes into these. And so what we have not yet discussed is this list right here. I know this is a pretty daunting list. However, these are the only class ones that we still have to review. So that list has been knocked down significantly, and those are the heavier violations. So the rest after that are class twos. Certainly a lot to talk about here, but not as heavy and really relevant to our discussion last week. When we get into the class twos, we're also looking at this as something that a supervisor, commander, manager can handle informally, just as their role, as opposed to sending all of these to internal affairs. So as we look at it now through the lens is, can we or should we assess these with the possibility that a supervisor could handle? And I'll give you just an example of tardiness that you see here. I mean, those should not be automatically referred to internal affairs. I think we can all agree on that. If we have an employee that's late to work, a supervisor should feel empowered to be able to mentor, train, counsel that employee and get them back on the right track versus these other heavier ones that we talk about with class one. So I thought we would start today. If there's no discussion on or no questions on where we've been and where we're going. Timeline wise, it's hard to say, but I mean, if we tackle, I don't know, at least five of these, I think we can move pretty quickly through these. So I say we just start chipping away at this list. Last week we left off with notification. This one right here is a class one section. So I thought we could start with that if there's no objection.
Sorry. No, this is great and super helpful being able to see it all laid out like that. And I agree. I think we've made a lot of progress. Definitely we could pick up, want to cover and finish these class ones, see where we're at, and then continue with the class two. And yeah, and I agree. I think if the class two ones aren't, I could imagine there's some that are more just straightforward and we can move through them a little bit more swiftly as well too. So, but for this evening, yeah, let's just let's try to get through this class one list and just kind of see where we get through as we move through
Okay,
these last class one violations.
great. Let me see here. Okay, so there was a question last week about this section. This is notification. So any member or employee who is a party to any of the following incidents shall prepare and forward via email or a hand-delivered memorandum directly to an IED commander within 72 hours. So if the member or employee is given a lawsuit, the only exception to this is if it's a lawsuit where the city of Oakland is named as a party, and in that situation, the city attorney would notify us. That does happen. A subject is arrested, which is more common of an example, and I'll come back to that here in a second. Their California driver's license is suspended or revoked, or notification of CDL suspension or revocation. If the member is cited in lieu of arrest, except for a vehicle code section or infraction. Note there does say infractions, not misdemeanors. I can come back to that. Served with a civil or administrative process related to their employment or which contains allegations which rise to the level of a manual of rules violation. Sometimes, and I'll just pause there, like an example would be sometimes we have employees who are landlords or tenants, and they are served with some type of civil or administrative process related to that. It's not necessarily related to their employment, but it could come to a manual of rules violation. So that's one. If it is related to their employment, then we would also, so sometimes there are civil matters that are related, that's not necessarily criminal, such as I was served 1 years ago for this. I was the investigator for a traffic collision, and it was a civil violation between both parties, and I was served as a witness to that because I did the investigation. So in that case, I would have to notify internal affairs. Anyone who becomes aware that he or she is under investigation for any misdemeanor or felony in this or another jurisdiction. And we do get these sometimes for family issues and other things. If circumstances prevent compliance with the timeline, for example, the person is incarcerated, hospitalized, or out of the country, the member employee shall make such notification as soon as practical or notify his or her unit commander who shall prepare and forward the email or memorandum. Notification shall include the date and time, location of the incident, involved parties, and summarize the circumstances of the incident. Notification by any other means shall not satisfy the requirement of this MOR section. So that's how it's written. As you can see here, this is pretty long. So I just tell you just some of the unique things about this. Whenever we have like a timeline here, so it says set within 72 hours. That's in there, there's a lot of assumptions, like if someone's arrested, it's like, okay, are they likely in a position to where they can make the notification within that timeline? And we haven't had issues with that. But there's a couple tripwires here because in our internal affairs policy, M3, as a Mary M3, it requires 24 hours notification if I become aware of something. So let's say I see an officer commit misconduct, I'm required within 24 hours to make notification. So then it begs the question, it's like, okay, well, why 72 hours here? One, it assumes that you're the subject of that investigation, fine. But should we entertain the idea of making it sooner than 72 hours? So that's really my first question as we look at this section.
Does the 72 hours account for these circumstances where people just can't report within the first 24, 48 hours?
Yeah, and that's really the assumption that it says here at the bottom. It says, prevent compliance with the timeline, incarceration, hospitalized, or out of the country. It says as soon as practical. So they gave a lot of grace here by saying 72 hours.
And the other one is the assumption if you see misconduct, like there's no reason you should be waiting. You need to report that right away.
So that's in a different policy, and
Yeah.
that's a little bit different. And it's a different also section where it's a failure to report misconduct, which is also a class one. So this is where you're the party to, and you fail to make notification. um, Maybe I'll just go down as you think through that. This was written back in 2010, so communication is actually a lot better now. We haven't really had a problem with this except for people who are just ignorant to this section. And I'll give you an example. An officer gets arrested for driving under the influence. They followed the M3 policy by making notification, but did they email or hand deliver a memorandum? And the answer is usually no. They don't think through that. They think, hey, I know that notify the watch commander that I got arrested, but did you email or hand deliver a memorandum?
Mm.
So they get sustained for this section.
Well, this seems to me to be the disciplinary section that speaks to the OPD sergeant who had the accident, didn't report it, fired off a gun in the elevator and didn't report it. A chief lost his job because of it. So this is a very severe. We've had some very severe issues around this. Am I correct?
Well, let me just go to this other section, and I'm going to hold off on answering a question until we see this. Let me see here. Forgot the section here, but okay, so it's this section 314.48, reporting violations of laws, ordinances. Members and employees who become aware that other members and employees violate law, ordinances, rules of the department, or disobey orders of a class one violation or a class two, which indicates a pattern of misconduct of which they are aware, shall within 24 hours or sooner report the offense. So this section is not where you're party to something per se. So if we go back to the other one, the example, they weren't party to anything, as in they weren't arrested, they weren't served anything. But this section applies because they were involved in a level or alleged class one and they failed to report it.
Exactly.
Yeah. So this is the more applicable section for that question. And yes, people have gotten in trouble for this section, not the other one.
For the scenarios that Deacon just described right now, you're saying it's the other policy.
Right.
It's
That's right.
more appropriate. Okay.
Well, I'm confused. You mean this 314.48 is different from what we talked about earlier about reporting?
It is. Yeah. Yeah.
It seemed like they're the same thing.
Yeah. And that's why people get confused.
Mm-hmm.
Yeah.
Well, why do we want if
Yeah.
And
if
now
you're
that I'm
leaving
thinking
people
about that,
confused, then it's a bad policy.
and that's what makes me even more confused around the email and hand delivering the notice. And I'm thinking that's maybe why they gave them 72 hours to give them time to actually get down there and hand deliver something.
Yeah.
Well,
it's bizarre.
If we're writing policy and we have two entities and they are confusing and convoluted and we don't know which one applies. So then what happens is none of them apply because you have arguments against both of them.
Yeah.
So we don't want to leave a policy like that. One of them has to go.
Yeah.
It should be one policy that says, look, if you're involved in a part one a misdemeanor or a felony action, and you got 72 hours, I don't care how time, that's immaterial to me. You have to report it, and if you don't, that's a serious violation. We shouldn't have two, because that confuses people and you divide which way to go. So consequently, if there's a fork in the road, if you come to a fork in the road, take it. You don't know which way to go, left or right. You've left the people confused still. I hope I'm making myself clear.
Yep, you're exactly right.
So one of them has to go.
Okay, yeah. So this one I would say is a little bit more obscure to people. It's more technical. It does have to be merged because one can receive a lawsuit and not necessarily be, well, it could be civil certainly, but they can also like be a witness or something. So it's not necessarily misconduct. So we have to make sure those two things are hashed out.
Okay.
Yeah.
But it's got to be one policy.
I don't disagree. Yeah. So this is 31428 and just scrolling down again, it's in the same family. That's why it's 314, but this is the reporting of. So any objection on me merging these two together?
Oh, sounds good.
Okay. Okay, let me go back first to 28 because we were talking about it, and I will combine these to make it more clear. How do we feel about the timeline here? So you have one that says 72 and the other says 24.
I mean, I guess it depends on which parts you merge. If we're going to keep the hand delivering and email part of it, I mean, it just seems like that's why they went towards the 72. And if there's still a requirement to hand deliver something in person, is given the scenario, like if somebody's actually in a drunk tank or something like that, and they're not able to actually meet that requirement within 24 hours. So maybe parse that out of like the notification and then 72 hours to actually hand deliver something.
Why don't we split the difference and just say 48 hours?
There you go.
I just have to verify if that conflicts with our other policy, but I'll look into that. The one consideration for this is I really don't like the hand delivered memorandum. I mean, that to me is unnecessary.
Yeah, I
That's
think
old school.
Oh yeah, I was about to, that's 1980s.
Yeah, we might as well say it has to be written on a typewriter.
Yeah, right.
So I'm okay with getting rid of that. I will say that an email is, we have another policy for criminal notifications. It's a phone call and email. So if I make notification to the chief that a member got arrested, let's say, I would call him and then follow up with an email or proceed it. Doesn't matter. But that I think is essential. So I like to change this to be a phone call if possible, because there are some situations where you can't, but definitely an email because there's an email or paper trail to go with it. Okay. Okay. And then I'll research that on best practices for the 72, 48, 24, because I'm pretty sure we have to follow the 40 or 24-hour rule for various reasons. And I'll cross-reference that with policy. Okay. So as we look at this list here, anything you want to add or take away? Lawsuit, the member employee is not required to report this section when the city is named as a party to the lawsuit. Any issues with that?
No.
Okay. Arrested. Any questions on what actually arrested means? Because we can have a debate over that too. I'm sorry, that was a loaded question. Here's an example. Brian
Does
Hubbard
that
gets,
mean being charged? Well, does that mean like how does like the charges and all that stuff happen?
yeah, well, I mean so charging would come later. So this is just the preliminary custodial arrest of an officer
Gotcha.
or a member. What if the officer lets them go? Like they're arrested, they're assessed, officer lets them go due to lack of probable cause, but they were arrested at one point during the encounter.
Well, 849B, you could be unarrested, but but the fact that you got 849B means that you were arrested. So all we're talking about if you were arrested, not the final adjudication of the situation. So we want to find out if you were arrested. You could, and you're innocent to proven guilty. So this is not a matter of guilt. It's a matter if you were arrested. Were you taken into custody?
Yes, right.
So if the answer is yes, then you ought to notify us.
Okay. It says here cited in lieu of arrest. Now that would assume that a citation is given, but it's not always given. Sometimes you have the officer who lets one go and says, I'm releasing them pending further investigation. Now I understand from the officer's perspective here, but we're putting a lot of reliance then on the member to report it. They can easily say, yeah, I was handcuffed. I never was told I was under arrest or blah, 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 but I don't have a citation. So how do I know I was 849 beat?
Well, if you were well, you got to sign 849B.
Well,
you can't, they just don't say you are 849. You have to sign it and you get a receipt. So if you're handcuffed, that's not an arrest.
Right.
That's you're just detained. So if you're arrested, you're told you're under arrest for blah 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 blah. If later on, a year from now or 10 minutes from now that the handcuffs were on, they're taken off, you still was arrested for that 10 minutes. So I think OPD wants to know that for several reasons. One reason would be maybe we have an agency that are abusing our officers. And maybe Captain Hubbard wants to make a phone call to Captain whomever in that agency and say, you need to talk to Reggie Lyles about what's happening here. It's going to create some bad feelings between the agencies. So all of that means you have to know if somebody was handcuffed, arrested, if they were arrested, not necessarily handcuffed. If you want to put handcuffs in here, you ought to say it. But because it's not in here, handcuff is immaterial.
Well, I mean, yeah, I'm not there yet. I guess what I'm trying to get at is I want to make it to where there's no ambiguity on when a member is supposed to make notification. And if we're going to be playing with and this is more relevant during the COVID era where there's like almost encouraged to release people, and officers, what they were doing is putting in the report, they were released pending further investigation. So one can argue they were never technically under arrest, but I mean, we're pending an investigation. OPD should be aware of that. Right?
I don't know about that.
Yeah.
I think OPD ought to know if they were arrested. However, if OPD finds out that one of their officers is under investigation, that's fine. I'm not faulting them for finding that out, but I'm not obligated to tell you anything. I'm innocent until proven guilty. I'm told, and I was not arrested. No one told me I was arrested. They said I might be arrested pending an investigation. Well, might be is innocent. A might be arrest or we may arrest you means absolutely you're not arrested.
Okay. I got
that's a hard line. When you're arrested, that's what you want. That's when OPD has a right to know. up until that point, I'm a citizen, and I don't have any obligation to tell you I'm innocent. I wasn't arrested. I was detained.
Okay.
And I guess there's a reason why you don't have detained in here.
Well,
That's a
no.
bridge too far, right?
Yeah, but as you see here, becomes aware that he or she is under investigation for any misdemeanor or felony that is in another jurisdiction. You know, I mean, sometimes one can say, like, I could be detained and still under investigation. So that
Right.
would kind of fall under here, but sometimes someone doesn't always know the answer to that.
And,
Like, okay,
I think I wouldn't support that clause. I mean,
this one right here.
well, yeah, my job, I'm not obligated to help you convict me.
Right.
That's not my job. And even if I'm guilty it's not a matter of me being guilty. I'm absolutely innocent until proven otherwise. So I don't think that bullet should be here. If I become aware that somebody's looking into me and investigating me for something or whatever, but they haven't told me anything about it, I don't have to tell you anything. And I shouldn't be made feel that I'm obligated to tell you that. Why?
Well, yeah.
I,
Well, go ahead.
I guess I'm trying to figure out where one line ends and one picks up, because I could see everything that Deacon Lyles is saying right now, especially if like you're getting detained, being questioned, and then you're like, all right, I'm just letting you go. There's no record of anything. I didn't technically arrest you at all, right? So yeah, that doesn't make any sense that somebody would have to go and say, hey, I got, detained, or, there was a bar fight and they asked me questions and then they just let me go, right? And it sounds like it's pretty standard practice, like, upon further investigation in terms of those notes, because obviously if another witness comes 10 minutes later and says, no, actually that guy saw him punch a few guys, right?
Yeah.
Then that changes things, right? So that's what that clause does. But at that moment, there was no evidence. You let him go, or a warning, or whatever that was, where that officer felt comfortable enough to. But now, again, when we talked about patterns the last meeting, right, it would be interesting to know if, like, hey, that's happening all the time. Like, to your point, Reggie, like in your jurisdiction, this is happening all the time, or you guys always let our guys go, or you guys are always busting our guys, right? So I don't know. I got to think about that a little bit more, but I definitely don't want to be like, having guys have to report themselves in 24 hours if nothing ever happened. They just, had a conversation with a cop and they let them go.
I think the Constitution trumps this policy. Even though I'm sure every police manager would like to know if one of the officers were under investigation, but the Constitution trumps this policy. You don't have a right to know, or better yet, I don't have an obligation to tell on myself or to say anything on myself. And suppose I come and tell you I heard that I'm being investigated for something that I didn't do. That may diminish my ability to matriculate upward in the department. That's starting a rumor. So why would I want to harm myself?
I understand.
Yeah, self-incrimination is a hard rule, and we're not obligated to incriminate ourselves. But I don't know. This is America, and America's turned the corner. Maybe we going down a rabbit hole nowadays, and maybe every citizen.
The bullet point that you have highlighted right there, I'm wondering if that's meant like, I work with, a bunch of young folks and this and that. And I know that when they're under federal investigation, or when their phones are being tapped or things like that, they get notified by the feds. They'll send them a letter and say, hey, I'm just letting you know your name came up, or you've been recorded, or some other CI or somebody has named you in some other investigation, and you're not being charged, but we're giving you a notice that we're watching you and that your name is coming up in other investigations or something like that, right? I've seen those type of notices. And so I'm wondering if this bullet point pertains into an example like that, where if a cop gets that type of notification from some other outside agency that they're part of an investigation, I think in that, I mean, I totally agree. You're innocent until proven guilty, right? I'm like, hey, I'm not being charged. I'm just being notified I'm part of an investigation. But it almost feels like if there's like being the subject of an investigation, especially like a federal investigation or something like that, that like they would have to tell.
We have a Miranda warning that says I don't have to say anything. And I can take the fifth. I can take the fifth and not help anyone to incriminate me. So I don't think this belongs here. I think this is an overreach, and OPD shouldn't want to do that to their employees.
Right. I mean, the intent behind this is because the department can't be surprised with someone who's under investigation and they're out there serving the community. And just so it's clear on, maybe I'll back up on what happens in these situations. Let's say that Officer Smith.
Hey, T. Wayne, what's
up? Officer Smith comes to the watch commander and says, "Hey, I got arrested."
Yeah,
Deacon Lyles, we're going to put you on mute, sir.
You sent that out to everybody.
Deacon Miles, you're not on mute. I don't know if you could hear us.
We got him muted. Okay.
All right. Awesome. Thank you, Micah.
Should I wait for him or should I continue? I like to, if you don't mind, wait for him just because I think it's important. I want to talk about what we do with criminal investigations against members. I think that's important to hear.
Ricardo, you're muted too if you're speaking.
Sorry, I accidentally muted. Yeah, accidentally unmuted. Sorry. Yeah, no, that's right. There's a great conversation. Yeah, it seems like the last thing you would want is like something being leaked to the press in another jurisdiction, and then you're seeing in headlines that one of your officers is being investigated for some other stuff somewhere else, and you didn't know about it.
That's exactly right.
It's hard because Deacon Lyles is bringing up a lot of good points in terms of just constitutional rights and as a manager, right? I mean, I tell all my staff, especially because I do intervention and public safety work, and there's public perceptions, right? And there's things like that we, have certain reflections of our organizations, of the field, of our city partnerships, right? That like, hey, you get a DUI, you get arrested, and I don't care if you haven't gone to court, you haven't been charged yet, like I need to know, and especially like with violence interrupters, and it's more like a professional courtesy thing. So I don't know if it's like more of a coaching thing versus more of a violation type thing, right? Because if I end up getting blindsided, Captain, and as a manager, and I end up finding out, I get a call from Captain Humbert and said, hey, one of your intervention dudes got arrested. Do you know about that? I'm going to be embarrassed. I'm going to be pissed that they didn't tell me. But really, from an employment standpoint, I can't really do anything to them either. You know what I mean? It's more of a coaching thing. I'm going to have to talk to them and be like, hey, next time, right? So that's where I guess that's that boundary there. I'm trying to figure out where at some point it becomes an actual violation, Do we have anybody? Let's take this break. Do we have anybody in the audience? No, we don't have any attendees. Mhm. Captain, when it comes to like suspended licenses and like DMV related things, DUIs, does the department automatically get notified from the DMV, like regular updates or?
No, and that's the problem is that, this is why we put a lot of responsibilities on the members to tell us because we can't afford for them to be driving around out there with a suspended license. And a lot of times suspended or revoked license are, subsequent to some other event like a DUI. So
Mhm.
yeah, that's why this section is so critical to talk about because it's more than just us knowing the facts, which I won't say we don't care about, but at the moment we don't. We just need to know this is happening so we can do a risk assessment.
You know what else I'm thinking about too is what if somebody just is really bad at paying tickets and gets their license suspended all the time?
Yep.
You know, and then it doesn't get flagged because by the time it gets suspended, then they're like, oh crap, I got to go take care of it. They go take care of it, then it gets activated again, right? But there's gaps there where there might be like a 2 or 3 month period where there's a little, there might be a suspension or they're in the process of clearing it up, right? But if that's happening all the time, that actually now starts speaking to somebody's character, right? Their level of responsibility. So that, yeah, I mean, I guess these are all things that are checks and balances for the department to make sure that folks just aren't going off the rails and then serving the public right while they have all this crazy stuff going on in their lives. um and really to get folks the help and coaching that they need if they are certain patterns that folks are noticing. I think it's an important part.
I don't know if Deacon Lyles is off the phone. You're muted if you're.
Yeah, I'm sorry about that. I had a call from the church. So
Yeah, it's all good. Okay. We took a brief pause, but I wanted to talk about just the importance of this section, but also a little bit more background. This section, including just general notifications, is heavy to us because we have been surprised by media stories or things that have come out significantly later. And had we known about the incident, we could have started our investigation. So let me just tell you how we handle criminal investigations here. If any employee, if there's any reasonable suspicion that a member is involved in criminal activity, okay, and now the threshold is reasonable suspicion only, it's not probable cause, so it's far less, but a little bit more than just a mere accusation, then it has to be reported to our criminal investigations division. And the internal affairs side case is actually told. So our criminal investigations division is the one who does the investigation if it happened here in Oakland. If not, they liaise with the outside agency. So let's say CHP officer arrests an officer in another jurisdiction for driving under the influence. CHP does the investigation, and we liaise with them just to see what the status is of that case. Once the criminal investigation side is complete, then internal affairs then proceeds with their investigation. Uh, because it's a criminal investigation, internal affairs cannot just walk in there and start interviewing people. I mean, because because of the criminal overlap there. So when we say notification, we're not asking them to confess. We're just saying you need to notify us that this occurred and no further detail, just so we can do a risk assessment. What we can't have is an officer who is caught up in this alleged misconduct, whether it's true or not, and continue to be, let's say, assigned to the field. We have to do it. That's why these notifications are so critical. Yeah. So that's why I'm taking, like, even the arrested, like the oral argument, whether you're arrested or not, is important to me because it's more than just whether it's a custodial, you actually go to jail. There could be a massive investigation and we don't have any idea because the nuances of how this is written. So that's why I want to get it right, because a lot of things have slipped by us because of technicalities. So that gives you
again, again, the convenience of OPD's management and internal affairs does not supersede the Fifth Amendment. I don't have to incriminate myself. I'm not saying I'm guilty. I'm just incriminating myself. I don't have to do that. And OPD, I see why you would want, those are all legitimate reasons, but they don't rise to the level of my personal protection. And so the organization's inconvenience does not obligate me to say, I heard somebody or some agency was investigating me. I don't know the details, but I heard that. I don't have to say anything. That's incriminating in itself just by making that statement, especially if it ended up being in a civil case. Did you go to your boss and supervisor and tell them that you thought you were under investigation? That could be a preponderance of evidence that could cost me money and my family's welfare. So I think you would lose this. I think you would lose and lose it badly. I don't think OPD wants to have that. And trust me, I want to see OPD adhere to the highest ethical standards, but I surely don't want officers having to have to come in and say, hey, somebody told me that some agency was looking into me, and that's all I know. I just want to let you know so you can start your investigation sooner. Hey, that's not my concern. My concern, the primary concern for me is me. The individual rights does not get thwarted by the convenience of the agency.
Okay. All right. So we're okay with just these first two, lawsuit and then arrested. Anything to add on there?
I guess my only question would be, is there a need to establish what that threshold is at the point of which, not at this point, you need to notify somebody? Would that just be at the point of arrest?
As one, and I'll probably put in there arrested as defined in California law. So there's, it's more than just the handcuffing or, just it needs to be the California law arrest.
Gotcha.
Yeah.
Okay.
CDL suspension or revocation notification, or notification of suspension or revocation. Cited in lieu of arrest, except for vehicle code infractions. Okay. Served with a civil or administrative process related to their employment or which contains allegations which rise to the level of a manual rules violation.
What is an administrative process? What does that mean, to be served in an administrative process?
Yeah, I don't know if I've ever seen this, but again, officers are oftentimes served with some type of
like a divorce.
That's not related to their employment, but that would fall under probably lawsuit type thing.
How about if someone violated a stay away order?
Yeah, that's certainly one.
In a divorce.
Yeah, that
would be an administrative process.
Yeah, but it would be more the secondary. It rises to the level of manual rules because that's a law violation.
Okay.
It would be both of these actually. But specific to their employment, sometimes officers, because they write reports or just witnesses of things, they would be subpoenaed as a witness for another civil matter. So they don't know the parties. They're just subpoenaed like, hey, you wrote this report. You need to come into court and
gotcha.
You're deposed.
Okay. Got it. So the only one that question was that very last bullet point then.
Yeah.
Is there a way to see what other comparable departments or what best practices around that? Like, there's something that unique to OPD that they just put in?
I'm sure that other departments have it. I don't have it readily handy with me, but I can look into it more. I can't think of an example, a real example, to where someone was completely caught off guard by some type of notification that they're under investigation for a misdemeanor or felony. Usually it's happening in the moment, even
Mm.
if the only thing I can possibly think of is like a hit and run allegation where maybe the member legitimately did not know that they were involved in a hit and run with another vehicle, and then all of a sudden they're getting notification by department that they're being investigated for that.
Mm.
And that should be known to us for many reasons.
And this is involved in an accident, a vehicle collision that's not city properties. Their own private property, their own private car or truck
I
or
mean,
business.
it could be both, but moreover, private. We do get domestic issues. I mean, that's not uncommon. Child custody issues, we get those. So those are all non-work related matters that might not be criminal but civil, but sometimes there's overlap there. And we have sustained members for not telling us, not making notifications. And so just to give you even more context, the Department of Justice notifies us when there is a member who's been arrested. They do it digitally, and yeah. So the first thing I do when I get this is I look to see if we already knew about it, and if so, then I just add it to the file. If not, like this is the first I've heard of it, then I start looking at this section here and general reporting of misconduct. The other thing is, I would say just something to consider also is, let's say that I'm arrested by CHP for driving under the influence, and in front of me, CHP notifies the department like, "Hey, I'm calling the watch commander right now. This is CHP." Is that notification? And so this is another technical violation here, where it's like, well, why do I need to notify the watch commander when CHP just did it for me? So then, am I required to do a follow-up notification? That's worth discussing in this section. Or is one notification enough? So just make a note here so I remember to update this. Okay. All right. If circumstances prevent compliance with the timeline, so incarceration, hospitalization out of the country, the member employee shall make such notification as soon as practical, or notify his or her commander, who shall prepare and forward the email or memorandum. All right. Any changes to that? Again, I don't really like this memorandum stuff for many reasons. That is not a common practice anyway. So I like to get rid of that. I shouldn't. Email is preferred for many reasons because
Expeditious.
yeah, but
Do it.
emails can go sideways also, as in accidentally forwarded, replying all, or some other thing. So there's some control issues with emails, but
Well, that's the responsibility of the adult officer.
yeah. Yeah. Okay. I mean, as I look at this, I think our idea of merging, and I'll go back to a 348, 31448. I want to make sure this comports with our M4.1 policy, which is criminal notifications. And as I look at this, I just don't think it really matches well. So I'll come back next week with maybe some edits that will make more sense. So here's the other problem that I see with this. Notification shall include the following date, time, location, involved parties, and summarize the circumstances of the incident, which I don't really like because this is where we get into some incrimination. So it's like summarize the circumstances. So am I telling on myself? And
No, it's
yeah.
not fair.
So what do you think for this? What can I say here that's different?
I think you get notified. That's it. Succinctly, and that's it. I'm not to do your investigation on me. And I'm not to come and confess to you. You know, the Miranda law is sacrosanct to me.
Okay. All right.
I
I
agree.
will. Okay. All right, I'm going to just go really quick to 48 just so you can see what's going on here. So this is the reporting violations of laws, ordinance, rules, and orders. Rules, orders. Members, employees who become aware that other members or employees violate laws, ordinance, rules of the department or disobeyed orders of a class 1 violation or any class 2 violation which indicates a pattern of which they are aware shall within 24 hours or sooner, if practical, report the offense orally or in writing to his or her supervisor or the internal affairs division. Members and employees who know of actions or of behavior of other member employees which are considered class 2 violation and do not indicate a pattern of misconduct may address the misconduct through non-disciplinary corrective action. If the witness, member, or employee believes the incident is so grave and or serious, he or she shall immediately report the incident to the chief of police. The chain of command may be bypassed. Discipline up to and including termination will be assessed for failure to comply with the provisions of this section. I am willing to guess that this is probably one of the first sections that were written. It's really the heart of the negotiated settlement agreement. So that's why I don't want to water this down by merging something, but this obviously has a lot of weight to it because, going back to the heart of the NSA, misconduct occurring and no one reporting it.
Yeah, but the way, again, having those two sections that has a minor difference between the two, it's confusion. And so you don't want to leave your constituents confused. You want them to be decisive of what they must do. So I think taking one of those 314 sections away will strengthen this. Doesn't weaken it.
Yeah. Okay. Any amendments that you see here? It reads kind of weird, so I think I'm going to fix that. But the one thing that I guess I'm kind of bothered, this paragraph doesn't really fit because this is more of a message to the supervisors and commanders, as in members and employees who know of actions that are behavior of another member, which are considered class 2, because we talked about last week, do not indicate a pattern of misconduct, may address the misconduct through non-disciplinary corrective action. But
Yeah.
it doesn't really speak to peer to peer. So whenever
No.
you read this, it can be like, oh, well, that's the supervisor commander's job. But I have a squad mate that's always showing up late. I want to address it. I should address it. It's actually probably more impactful if I do it to a fellow squad member versus a supervisor commander, because there's a lot of peer pressure there.
Well, yeah. And this doesn't prohibit, you got freedom of speech. You can go up to the guy, over coffee or at the locker and say, man, you need to show up on time. Yeah. And none of this prohibits that. But this is for supervisors. So you should have this should be subtitled supervisors or something, supervisors : because peer-to-peer doesn't have any authority over each other. In that peer pressure that you're indicating, that's not an official supervision tracked. That's socialization. That's not in the chain of command.
Yeah. All right. I'll do a little fixing on that. I want to change this also. It's okay to say the chief of police, but I want it to be, I mean, it really should be anyone. Because if we're saying that all members are required to make notification within 24 hours, that means if I'm on the other end of receiving this notification, I am now empowered to do something with it. This could read, well, I don't feel comfortable going to my chain of command because they're part of this corruption.
Yes.
But I don't have the chief of police phone number. So now what do I do? Versus I can go to anyone, including any commander, any manager, any supervisor, any fellow officer, and say, this is what's going on. I need you to report this for me.
But it, again, yeah.
Is that any fellow officer or any supervisory officer? Any
I mean,
command?
I would say management officer.
Yeah, I
Yeah.
mean, it could, or supervisory. I mean, that's fine, but also like I don't. To me, it's like whomever you're comfortable speaking to is, if it's so grave, I think it should just be anyone you're comfortable speaking to, and know that they are then responsible for doing something with it.
Did they have chief of police in here so it gives the offended party the knowledge who's reading this that you can go to the chief of police, you can knock on his door or get an appointment with him. So that's the purpose of, I would think, having the chief of police there. Otherwise, Officer Smith doesn't just go up to have a word with the chief on a Tuesday afternoon.
Yeah.
So he knows better than that. But what you're saying here is that they can go out of the chain of command.
Right.
Right. So
That makes sense.
yeah.
Yeah. I like to say up to chief of police, so they know how.
Up to and including the chief of police.
I mean, the way I read it is like, oh, this is a grave issue. They shall immediately report to the incident to the chief of police. Well, how do I do that?
Yeah, no, I don't know.
Yeah.
Up to and including.
Yeah. There you go. So anyway, I'm gonna change that also.
That's like being able to report harassment or
Yeah.
anything. You don't have to go to your supervisor or whatever. Go outside of the chain.
Okay. All right. Anything else on those two sections? So my deliverables for those two sections are to merge them, confirm the timeline to see if we want to follow the 24, 48, or 72. I'm pretty sure I have to do the arrest. I'm going to align it with California law. Change what you're notifying the department of, so you're not incriminating yourself, and then enhance the non-disciplinary corrective action section to empower supervisors and commanders, and then also who they can report to up to the chief of police. I'll fix that. Okay. All right. Got it. I'm going to highlight this so I remember that we talked about it. All right. Obstructing the internal affairs process, 31438. This one I'm definitely glad we're talking about because I have serious issues with this. Obstructing the internal affairs process, no member or employee shall obstruct, impede, delay, or undermine the internal investigation process in either words or actions. This is a highly debated one because I don't really know what that means. When you just use words like obstruct, impede, delay, or undermine, those are really conclusions not supported by facts. Like, what does that really mean? It has been challenged many different ways and times. The most common one that we see here, just for the mere allegation, members talking about internal affairs investigations with others, and there's no intent behind this per se. It's, one of the questions we asked in an internal affairs interview is, did you speak about this case with anyone? It's like, oh yeah, I was telling officer so and so, but they weren't involved, so it doesn't really matter. So it calls into question is like whether you're conversing with someone obstructs the process. That's one of many examples. I'll let you sit on that for a little bit. Anything to add or take away here?
Well, in the example you just gave, Captain, would they have at some point been given explicit instruction to not discuss anything in the investigation to anyone?
Not at that time. It usually comes as an admonishment after they're interviewed. So after you interview me as a witness or subject officer, you would remind me not to talk about this with anyone, and that will be it. But before, not so much. I think it's common knowledge per se, but again, the burden of proof is really on the department to argue how one obstructed, impeded, delayed, or undermined the internal affairs process. And if I can add one more thing, that's even more confusing with this is, is it? I mean, we already talked about it. Oh, it's interfering 39870. I'll give you another one that's very closely associated. Okay, so this is interfering with investigations. Members and employees are prohibited from contacting any witnesses, complainants, or subjects involved with internal or citizens police review board. Again, needs to be updated investigations for the purpose of discussing or influencing their testimony or persuading them to withdraw complaints. When routine contact with such persons is unavoidable, members and employees shall refrain from any discussion of complaints against department personnel or testimony related to those complaints. So again, it's two sections that are really close together. And the more common one is interfering with an investigation. But it's like members and employees are prohibited from contacting witnesses, complainants, or subjects involved. So can I interfere without doing that? The answer is yes, sure I can.
I don't think we can cover every possible way someone can interfere. So I think the general language that says um, um, with the internal or citizen review board investigate for the purposes of discussing or influencing their testimony or persuading them to withdraw complaints. I think that's a broad enough sentence that covers, I think, most of the ways you can influence someone.
Mm.
You know, I just took her out to the racetrack. We just went on a date. But your purpose was to influence. And then it would be the department's responsibility to prove that.
Okay. Let me go back.
It's just so many ways you can influence, someone's investigation. You couldn't cover it all in a paragraph or several.
Okay, so going back to obstruction then, are we okay with?
No member of the employee shall obstruct, impede, delay, or undermine the internal value in either words of action. Yeah.
I think that's pretty straightforward.
Yeah, that's
Okay.
pretty straightforward. Broad, and then the job of the department is to prove how it was impeded or obstructed.
Okay. Okay, I definitely wanted to come back to this. I think we touched on it, but so this is 31439. This is the performance of duty. And we somewhat talked about this, but didn't really. I don't think we finished it because I think we got sidetracked with some of the subsections here, but this is a very, very common section that we use. Very common. All members and employees shall perform their assigned duties and responsibilities as required or directed by law, department rule, policy, or order by a competent authority. Each member and employee is accountable for the exercise of delegated authority and shall not conceal, divert, or mitigate their true culpability. Violations of performance of duty may include, but are not limited to, the following: intentional illegal search, seizure, arrest, unintentional or improper search, seizure, arrest, unintentional, planning of evidence, failure to perform duties as required or directed by law, departmental rule, policy, or order, improper care of property of persons, and changing a work assignment without authority. So what's not listed here but we use is Miranda. So this is where we incriminate someone without, or one incriminates themselves without us Mirandizing them. That is, I see 1 or 2 cases a year of that, but it's not listed here. So that's one thing I want to add on here is specific to Miranda, but
how would you word it? Failure to offer a Miranda warning to an arrested person?
Yeah,
arrested?
Yeah, but I think I would
mirror interrogation.
It would, it would mirror something like this, because I think if it was an intentional act, it's far more severe, because this insinuates intentionally violating one's Fourth Amendment right versus the unintentional violating of one's Fourth Amendment right, similar to the Fifth Amendment, intentional. But I also want to add the Sixth Amendment here, which is, after charging, and so, because that's been another one where we've seen Sixth Amendment violations, we don't know where to put it, so we just kind of loop it in with the Fifth Amendment. But it could be more severe depending, because one has already been charged, so it could be more severe. So it does complicate things.
So you would say the intentional failure to offer a Miranda warning to an individual who's under custodial arrest.
That's right. That's right.
Does that usually get discovered through a body cam footage review? Or do you guys usually catch that?
Yeah, it's yes, it's quite often body worn. I mean, I've caught a few myself. It's body worn camera review. Sometimes the district attorney's office notifies us of that, but it's often just self-discovered.
You mean the person who was arrested doesn't say, man, this guy came up and started interrogating me. He never gave me a Miranda warning.
We get a lot of those complaints, but the person's not in custody, so they just don't understand the law. But yeah, we do get those too. So someone is actually arrested and they're questioned, and then yes, a lot of times people will just say, you should have Mirandized me immediately upon arrest, and it's like, well, we're not questioning you. So those are yeah.
How do you guys train? Do
yeah.
you train like you don't have to do it until you question someone?
That's right. It's custody plus interrogation. So it's when the officer is going to interrogate. And there's a lot of reasons for that, but it's also they need to be very careful because, you know, some like what we found is a lot of officers are asking questions when there's no intent behind it. It's just, you know, they when they say, "Hey, where did you put that gun?" or "Why did you throw? What did you throw?" And it's like this small talk that actually is incriminating.
Well, why should I believe the officer if I'm a citizen? I mean, the Miranda warning is not to help the citizens out; it's to manage the police. The
Yeah.
whole idea is so maybe OPD ought to train. Look, as soon as you put the handcuff on a person, you ought to Mirandize them immediately. Get it out the way.
Yeah, I mean, the only problem with that is if a person waives, then oftentimes we're not in a position to actually interview them because we don't have all the facts. The other part to that is sometimes when we make arrests, there's our criminal investigations division. I'm sure you're familiar with this, the call out, you know, they get called out from home to actually take over the investigation.
Right.
And we want them to do it. So it's not the line officer out in the field. It's like, and we just tell, hey, listen, someone else is going to talk to you. So I'm not going to ask you any questions. So that's how we train. It's like, make that explicit. Like, I am not going to ask you any questions about the crime. Someone else will do that.
So let's don't do any chit chat.
That's yeah.
All that chit chat is being slick.
Mhm.
I'm telling you, it's being nefarious.
Yeah.
Or that's how it's going to be perceived by the citizens who you want to trust you.
That's right.
Exactly. Yeah.
They're gonna see you as being, you know, trying to be, you know, slick, you know, sly.
Two-stepping. Remember
Yeah.
that? Right.
Yeah.
Yeah.
You look, man. Oh no, I wasn't asking him anything. I just asked him when the last time he seen his sister, who happened to be lying in the back room with a bullet in her head. You know, you can't do that kind of small talk. So there's some value to getting that Miranda warning as soon as somebody's under custodial arrest. Get it out there. You know, so he's been Mirandized twice or 3 times. So what? You know. Then if somebody wants to make spontaneous submissions, it's acceptable.
Yeah. Yeah.
Because you know, you people cry in the back seat of a car. People cry and they whine and I should have did it. I'm sorry. They say all kind of stuff. That's incriminating.
Yeah.
But
I mean, we also teach an assessment on the person's well-being because we could talk again about juveniles here. It's like before you launch into because we can't. There are now laws surrounding that, so we have to confirm a lot of things before we launch into Miranda and interrogation. If they wait,
juveniles are different. I'm talking about full-grown, 2-time losers. You know, I'm talking about, you know, guys who are grown. Get that Miranda out the way. Or stop the small talk, the chit-chatting.
yeah. So I'm going to add that. I'm going to add fifth and sixth. Anything else on this list that this is somewhat of a catch-all section that we talked about before, where if we don't find a place for it, it usually fits here. But as you can see, I'm not sure why they limited to the 6 bullet points here. But there's a lot more that we can certainly add. I mean, like for example, the fourth one here, failure to perform duties as required or directed by law, department rule or policy or order. And that's where it's a catch-all. So the Fifth Amendment issue that we see, it's not explicitly written here, but it's like, okay, well, that's a direction by law, and you failed to do that. I am somewhat tired from using that fourth bullet point only, so that's why I want to create a standalone Miranda Sixth Amendment section because we do see those.
Makes sense.
Yeah.
You keep saying Sixth Amendment. I'm trying, and I don't understand it as such. I mean, make me understand why you say Sixth Amendment.
Yeah, so someone is arrested for, let's say, a robbery, and they're charged by the DA's office, and our CID is investigating them for another robbery. Because they're charged by the DA for the first robbery, they can't go in there and question him. That's a Sixth Amendment issue because he's already been charged.
Mm.
Yeah, so they actually, and we do see this. And it's not a Fifth Amendment argument, it's six. So they need to go confirm whether he's afforded an attorney for the first robbery to question him for the second. Yeah.
So you saying it's unfair to ask somebody about a second robbery because they've been charged on the first one.
That's right. Well, it's
the fairness doctrine. Okay.
I mean, it is a Sixth Amendment issue. Yeah. And you know, the good thing, I mean, more than a good thing, this rule that we have and then we teach this is it requires people to slow down, as in don't just go running in there and questioning them. You need to, he's already in jail for something. So that means you need to go find out why he's in jail and figure out if I'm allowed to speak with him. And you could easily find out nowadays that they have been indeed charged. So therefore they need to be afforded an attorney. So usually it's our investigations division that get these complaints because they're the ones who are, you know, interviewing someone who's already in custody and charged. Yeah. Okay. Any questions on 31439? That is a class one. So then the question is that I have for you all is whether okay, I'm sorry. As you look down here, we have unintentional proper search, seize, or arrest. Okay, so if an officer unintentionally crosses the line for the Fourth Amendment, then we would call that a class 2 violation. Do we want to do the same for Miranda, where we make a class 1 is intentional, class 2 unintentional?
I don't understand how Miranda could be unintentional.
I was going to ask if you could give us an example, maybe.
Certainly. I get into a foot chase with someone, they discard something, and I catch them, I'm out of breath. They say, "Hey, what did you discard?" And let's just chalk it up to me not being a runner. You know, I'm emotionally, my heart rate's 190. I'm tired. Hey, what did you throw? Or why did you throw what you threw? Or why did you run from me? Okay, sometimes we just blurt that out and the person doesn't answer, or I never use that against them. I never put in my report. I don't care what their answer is because they're under arrest. Let's say I could say, "Hey, listen, I didn't mean to violate his Miranda. I asked a question because I was tired. I blurted it out. I never use it against them, but it would still technically, if they're in custody, you ask them an incriminating question, that could be construed as a class 2 unintentional."
Pretty strict.
Well, I mean, let's be honest. Like, let's say, I mean, truly, you read my report. I never use it against them. I never like say, "Hey, they told me this, and I want them to be charged for this." I literally did nothing with the information.
Hey,
But that could backfire too.
if you chase somebody down the an alley and tackle them, you got them in custody. Where did you throw the gun? You mean I got to Mirandize them for that?
Well, you can use the public safety exception for that. Let's not use a gun. I purposely did not say gun for that reason. Because
Okay.
Yeah.
Because there's the public
You
safety.
made that
Okay.
clear. Thank you.
Yeah. Okay. So let's just say that. Let forget about throwing something. Hey, why did you run from me? That's a question that I can use against him based on that question alone, right? So that is technically a Miranda issue. But let's say I just it's an emotional response. Hey, why did you run from me? And I never do anything with it. Are we going to call that a versus, hey, why did you go murder that person? Why did you murder that person? What gun did you like outside of Miranda?
I don't want you putting a class 2 in the Miranda, because what happens is everything will sink down to class 2s, and they'll justify they're all class 2s. Leave Miranda like it is. It's a class 1. It was hard fought, and let's not weaken it.
Okay.
Police officers have to warn people, and the trend in California is going towards more warning, not less, with their new legislation with juveniles. So I don't think there should be a class 2 on Miranda.
Okay.
If a person says, "Why did you run from me?" and they never use it, hey, no harm, no foul.
They'll get sustained for that.
You guys are not, the things you guys ought to really be going after people for, you don't. And then you go after somebody for that?
Well, it's not about going, if the person says that they were not, we have to investigate it, remember? And so we look at literally what the policy says. And if it says Fifth Amendment, then we sustain. That's exactly why there should maybe some consideration for class 2 for those other situations where, yes, it is sustained. Done a better job.
Miranda is too valuable to weaken it. When you put a class 2 into it, water seeks its own level. Everybody will be arguing, "Oh, this is not a class 1, it's a class 2. No, don't do that. Don't open up that Pandora's box. You violate Miranda, you didn't give a person a warning. That's a class 1 violation. It's a federal offense. Okay. Yep. It's a constitutional right. So no, we don't want to weaken it to make it a class 2. I'll never agree to that.
All right, great. I know where the line is drawn. That will keep it at class 1, but just know that we do get these obscure ones where we know there's.
You guys ought to be more benevolent than that. I mean, the intention was not to interrogate the person. That wasn't an interrogation. Why did you run from me? This is an investigation phase. It's not the interrogation phase.
Mm-hmm.
Well, where's the girls at? Are they down in the basement? You don't have to Mirandize anybody for that. That's part of the investigation. Interrogation is when you're impeaching someone.
Mm-hmm.
You said that the people were downstairs in the basement. In fact, they were in the attic. You lied. I don't think why did you run from me? Do you have any more people in here? Any more gang members inside? Where did you hide the money? I'm not Mirandizing anybody for that.
If they're in custody, I know exactly what you're saying, but we do have these technical issues.
And that is
more mitigating. So what happens is the officer will be sustained, and then those are mitigating factors to kind of bring down the severity of the discipline. But if we're talking about straight going by the letter of what we write in here, that would be a sustained case if they're in custody.
Okay, if you guys are not going to yield on that, let it be a sustained case. The value of Miranda as a Part 1 violation for someone intentionally violating it is too serious. It's too important to the freedom and movement and pursuit of happiness in the United States.
Okay.
In the example that you gave, when they're chasing somebody or something like that, when would that come out? Would that come out because the DA's office had to throw out a case because it turned out that he did incriminate himself and all this? I mean, I just
wouldn't use it.
Yeah, I wouldn't use it at all, because I think, it's a penny piece too, because if somebody is willing to talk to you, like if out of just human instinct, you're pissed, you just ran a mile, you're just like, damn it, why did you run? Right? It's just like, right. But if somebody's going to then incriminate themselves off of a casual question like that, they're probably going to talk to you anyway. and then you're going to lose valuable information that you could have used if you would have just not said that question, right? So then it becomes a training thing, because now it's actually backfiring on you, because that person probably or maybe would have been willing to talk to you, but now you can't use that information because now he talked to you, but you off a question you just didn't really mean to ask him, you know.
And I gave the example because that's what I see is like it's a question that officers don't even remember them asking because they're coming out of chasing someone down and they have no intention of using it. But I'm saying where we discovered though is I'm in my comfortable office watching body worn camera and I was like, oh, this person's arrested, and you just asked them a question that is likely to elicit a response, incriminating response. That is a violation of Miranda, period. And there's nothing I can do. So now we're talking about like, well, can I handle it informally? The answer is no, and treat it like a training issue because it's a class 1. I have to report that to internal affairs.
If it comes out that you saw that on camera and didn't, now you're on the hook.
That's exactly right.
Yeah.
So that's the issue that we deal with. I mean, we do have Miranda violations, like clear ones, class 1, no problem. But we do get those ones where, you know, we know what the officer was intending to do, which is doing nothing with the info. It's just they ask the question and it doesn't compromise the case even. But still, anyway, so I appreciate the conversation. It's good. And like, to me, my solution is this: if we're going to keep it to class 1, which is fine, and add the sixth amendment, we're just going to push the training out harder. It's like even under duress, you need to be very careful of what you ask and what you say to someone, and you have to control it. No different than controlling your tongue with profanity and other things that you could say under duress. Miranda is no different.
Mm-hmm. And to Deacon Lyle's point, I think, you know, part of what I get frustrated with, and this I think maybe just a larger discussion, but within the disciplinary process, you know, it's part of it is, you know, I want to make it clear that I think that when we're going through this disciplinary process, I want to make sure that we're focusing on the violations and the things that really get the department in trouble, that really like just break trust with the community, right? And the worst thing that I hate to do is have to come down hard on somebody, or even just not even if it's hard, it's just like, you know, it's fair, balanced, right? Even if I cut somebody a break and I feel like, man, I'm getting you in trouble and I don't have no latitude to coach, right? Because you broke the law. I'm seeing it. I'm looking at it on camera, right? And I gotta uphold the rules because we're trying to, you know, be as much by the books as possible. And it's just I guess it just doesn't feel good when we're really dinging folks for real minor things and being sticklers on some of the minor stuff, and then we're having problems on all these other major issues, and we're you know what I mean? And so like, how do we weigh that out a little bit, right? And then from a police accountability standpoint, we end up taking a hit that, you know, we're against you guys and we don't like you guys, and we're coming down hard on the disciplinary process, and we're just like, hey, we're just going with what's in front of us, right? What we can work with, which is why I've been open to these discussions around, you know, making class 2 violations, giving us more tools to have more latitude in the disciplinary process. But I really, you know, to Deacon Lyle's point, there's certain things, especially around Miranda, where it's just like, ugh, like I don't know if you know. I think we just need to think about that a little bit more as well, too. I don't want to lighten it up and then everybody kind of exploits that loophole with something as important as the Miranda.
That's right. And you know, I'm online here researching Miranda and when should it be given, and it's just someone's opinion. It's not sacrosanct, but it seems that it should be required during a custodial interrogation.
That's right.
Not necessarily an interview. Not necessarily I'm running down the street and the guy is down on the ground and I'm wrestling with him, you know, where's the person at? What house are you at? you know, that's I don't have to give him Miranda for that. You should not have to do that. You guys are going too extreme on that. And it makes me think, are you going so extreme on that so you can get a lower threshold for Miranda, where people who violate Miranda won't get severe punishment? That's what I'm thinking. Because how long has Miranda been instituted? 50 years?
Yeah.
So why are we messing with it?
We're not.
Okay.
But we also don't play games with it. So to us, if the person's in custody, then anything you ask that person is.
I agree with that. In custody.
Yeah.
In custody, you should give them a Miranda.
That's right. And that's the problem we run into. The person is clearly under arrest. You ask some questions, period. Done. That's a violation.
Okay.
Yeah.
Excuse me.
And so the other response to this, and understand not making this a class 2, and I don't disagree, is when we get to the discipline range, then we can maybe have some more latitude, as in allow those imposing the discipline the opportunity to aggravate or mitigate based on the facts of the case.
That's right.
Yeah. So that's another bridge we'll cross at another day. Okay. Okay, obedience to laws driving under the influence, 314.42. Members and employees shall observe and obey all laws and ordinances. A violation of the section may include, but is not limited to, the following: felony or serious misdemeanor crimes, other misdemeanor crimes, or driver's license status. So this goes back to our previous conversation. If there's reasonable suspicion that a member is involved in criminal activity, then we have a process for that for the investigation. DUI, excuse me, I don't know. I kind of remember this conversation back from 2009. But it does have its own standalone section, but it all fits within this family. Anything to add or take away from this? This hasn't been an issue for us. I mean, we know what it is. It's obedience to laws, period.
Yeah, no, that's all seems pretty straightforward.
I guess as I think about it, as I look at this, I know it's felony or serious misdemeanor crimes, other misdemeanor crimes, but it's not limited to the following. So we do get sometimes an officer was speeding, ran a stoplight, stop sign, driving recklessly, let's say. You know, I mean, technically, as you read this, when it says up, but may include, okay, it doesn't say infractions here, but it could include that. So we typically don't make that an obedience to law per se, like criminal notification, but we do observe it under this umbrella. Did they follow the law? Period. Yeah.
And this is pretty ticky tack, but I see cops parking red all the time.
Yeah.
I'm always wondering, like, are they allowed to do that?
No,
But I assume there's probably a public safety exception too, right?
there's not. I mean, we sometimes invoke it based on the circumstance, like if we were responding to a priority call. But no, we're not allowed to park in the red. I mean, ironically, we do get complaints for people saying that we should park in the red because we took up a space that they could have had.
That
get
makes
that.
sense.
We do. So it goes both ways, but yeah. Okay. Confidential reporting of misconduct, 3/14/49. I don't even know what this is. Oh, I don't see it here.
When numbers skip like that, Captain, does that mean they were just taken out at some point?
I think, either that or added.
Mm.
Let me see. Did I read that right? Maybe I wrote it down. Maybe they changed it to a different section. Anyway, okay. Well, maybe it's this one. I got to confirm that. Any member employee of the department, any member employee of the department may confidentially report potential misconduct directly to the commander of the Internal Affairs Division. Member employee reporting the alleged misconduct shall clearly indicate to the ID commander that confidentially for the report is sought pursuant to the confidential provision. Confidential reports may be made in person, by telephone, and writing. Confidential reports will be documented by the ID commander and kept in a secure repository, accessible only to the ID commander. The case shall be investigated without disclosure of the completed statement unless and until such disclosure is required by law. That can't be right. As in, it's like, that's like telling someone what they can do, but not what, I don't even understand what the violation would be. I'll have to research that some more. I don't get it. And plus it almost it bleeds into what we talked about before with 3/14/48 and 3/48/28.
Mhm.
Okay. I'll look into that. I'm not exactly sure how that happened. Let me highlight that one.
Looks more like just process that they're supposed to take when filing those.
Like they have the right to do it. I do have a safe. That is true, where I have a repository, but that's even archaic now. It's like we do everything digitally. It's for old cases. All right, I think we have time for one more. 3/14/69. I think we may have touched on this. Gifts, gratuities, soliciting, or accepting members and employees shall not use their authority or position, whether for him or herself or another, and not otherwise available to them as a private person, to barter or solicit any goods or services, except with the intent to convert to private use any goods or services from financial gain or other benefit, to obtain or grant privileges or favors, or to avoid the consequences of an illegal or prohibited act for themselves or for others. Members and employees shall not use their authority to solicit or accept contributions for the department or for any other agency, organization, event, or cause without the express consent of the chief of police or designee. Any member or employee who receives an unsolicited gift, gratuity, or other item of value shall notify the assistant chief of police, or in his or her absence, a bureau deputy chief, regarding the disposition of the item. If unavailable, prepare and forward a memorandum along with the item through the chain of command, documenting the circumstances of receipt. A lot going on there. This actually happened to me. I got a envelope one time with a basketball card in it of some basketball player I didn't even know, and I'm not exactly sure why I received it, but I did look up the section. I'm like, well, this is a gift. I don't know why it was sent to me. So I wrote a memorandum and I gave it to the chief. So I recommended that it be donated to our police activities league, but I did not accept it. So, I'll be open and honest about this. Like, I know, sometimes we have cultural issues with this where some cultures like want to gift things to others as a thank you, and that includes the police. And we're sometimes like caught in that. It's like, should we say no if someone wants to buy me a cup of coffee, or immediately report to the chief of police? This is far different than someone who wants to buy me a Mercedes for the work that I do. So there's a lot of misunderstandings with this section.
A lot of cultural stuff too. If you're in the community, working with families maybe impacted by violence. You step in that door, you're on that porch, you're gonna get offered some cookies, they're gonna offer a soda, a water, something, and in some culture, you say no a million times, they're gonna. The only way is not to get away from that is to finally say yes at some point, and so that makes it tough too in those.
Yeah.
And you know, and in certain cases, like we are trying to change culture and how community sees us, and so that's also a fine line too, right? But I don't think that's the intent of this. I don't think the spirit of this law was meant for that.
Yeah. Yeah, and it hasn't been an issue per se. I'm just saying as we dig deep into this,
Mhm.
like you do get the restaurants who insist on paying. And so what I tell the academy this when I taught this many years ago is like if you know what you're doing, if you're purposely going to that restaurant knowing that they're going to give you a significant discount or for free, then you just answered your own question versus the I'm going here to eat and then oh they bless me with this very nice gesture. In that case, insisting that you do pay or giving a very big tip, if you will, there's a difference between that. um and then of course the extreme side of this, and we have seen this in the past where absolutely leveraging your position for personal gain. Where we often see this, though, however, or I should say more often assessed in our internal affairs world, is this one to avoid the consequences of an illegal or prohibited act for themselves or for others. So let's say an officer is stopped for driving under the influence, arrested, and the officer is leveraging his position to get a reduced sentence or be let go.
Mhm.
Hey, I'm a police officer. I'm a fellow police officer. Can't you hook me up? Little things like that, like absolutely would violate this section.
Years ago, my aunt owned a restaurant in New Orleans on Gentilly. Uh, and this squad of officers would come in, 6 of them, and they would sit down and eat a big old meal. And I was at home once in the back helping her out in the kitchen and stuff. A police officer, sergeant, and she said, "I'm so sick of these people coming in there, eating me out." And so I went outside with the guys and told them, "Man, you can't come back again. You know, this is a mom and pop operation. Eating this out of house and home."
They wouldn't pay.
No, they wouldn't pay.
You just walk out.
Yeah, it's a different culture in New Orleans. You can go into a restaurant in New Orleans, and that is an expectation. You can go into a bar, and you can find officers sitting there at the bar drinking Jack Daniels in uniform.
Really?
Yeah, it's just a totally different culture. And the guy got smart with me. He said, "Well, who are you?" I said, "Well, this is my aunt's restaurant. And we're going broke because you guys are coming in here, once a week, 6 of you. And these are big guys, you know." And so words was, went back and forth. I said, "Well, that's all right. I'll be talking to the chief tomorrow about it." They never came back.
Hmm.
So that was the end of that. But it's just a different thing. So gratuity in the rest of America is different than it is here in California.
Yeah.
How do you all define an item of value? Is there
Yeah.
like a money? Is there a dollar threshold?
No. And that's a great question. The answer is no.
Because the unsolicited item of value, or kind of one thing that I'm thinking of right now is first responders get a lot of love, especially around crisis situations, right? And I think about the things in LA. There's a lot of restaurants, a lot of places that are like, hey, first responders could eat free here, right? I mean,
Oh, yeah.
then you would hate to have a whole department having to report that the whole department's eating free over here, and that could add up. So I'm wondering, like, how we make those exceptions,
And the other thing, I think we had a long discussion. I don't know if we got to go through it again, but it's when you recommend certain businesses
Mhm.
that can be a problem with rival businesses. And in some proprietors want the police and want the police car parked, in their vicinity. They want that perception of safety, So the locals who are nefarious say, man, the police are always around here. We'll go around the corner.
Yeah, it's tough. I mean, even the San Francisco Giants will have a law enforcement day where the tickets are cheaper. And it's, first responders, a general statement, but technically it fits within this. And it does confuse people with that. It's like, well, I'm not taking advantage of the San Francisco Giants. I am contributing to their appreciation for first responders by buying these discount tickets. I don't know. It's tough. It's a
it's
a wrestling match with morals.
We used to go up to Santa Rosa to the 49ers training camp.
Yeah.
And they would have a big barbecue and they would invite all the law enforcement up there. And the guy who ran it was a San Mateo captain still on the job. And he worked for the 49ers also.
Yeah.
His job was to organize. And the whole idea was that if one of the athletes, got a DUI or whatever, the 49, look the other way,
So is there a need, or are we just doing too much? But is there a need to like put a sentence in there and say, unless it's for like a department sanctioned events or something like that, that it's publicly known that everybody in the department is going to get a quote unquote gift from,
or a department sanctioned charitable event, leave it like that. I don't know, maybe open up Pandora's box there too.
I know. I struggle with it because in an ideal world, especially like when I'm thinking about like police oversight and building police and community trust, like we want a world where like, a bunch of school children, are going to do a bake sale and bring a bunch of, cookies to your office, captain, and thank you for your service. And you not have to be like, oh, I can't accept this. Like, and be all weird about it, so, and obviously that's why I'm asking, like, what determines something of value, right? And where does that threshold,
that's a good one.
become? But, of course, because again, in an ideal world, we want the community to be able to show their we wanted to get to a point where OPD is so loved and appreciated in the community that you guys are getting gifts left and right, man, and not like diamond rings and Rolex watches, but but a cup of coffee or like in the Latino culture, a piece of pan or something, just to be like, thank you, we see the difference we're all making together, right? So that's a hard one. But again, I don't think, it's pretty clear what the spirit of this law is, right? It's just that technically all these other feel good things kind of fall under that,
Yeah. Well, it'll give me something to research more. I'm actually, maybe it would be better if we had more community members weigh in on this, because a lot of this is about their perception. Like, what is your perception of what would offend you of gifts and gratuities towards a police officer versus a private person? And so maybe I can sit on this for a little bit and we can come back to it.
Right.
Okay. I
All
think
right.
voiced out for the night.
Yeah, I'm kind of tapped out.
Yeah.
All right. Well, it was a great conversation. We made some significant progress getting to those last class ones. I think over the next couple of weeks, Captain, looks like we got like what, 1, 2, 3, 4, about 6, 7 of them left.
Yeah. So 1, 2. Yeah, sure. For class ones. Yeah.
Yeah. So we probably could get through those in the next couple of weeks. And then once we get there, before we get into the class 2s, then we'll just kind of take a pause, recess. What would be great is if we could be like, all right, we're all done with all the class runs. Let's send the class ones up the chain of our first edits while we start moving on to the class twos, and then get, you know, those channels and all those other eyes that need to look at it, start moving on our initial, you know,
That's a good idea. That's a
you
good
know,
idea.
and get that process started. And at least we could say, hey, all right, we're done with all the class ones. Here's the class ones. Let's get that process going, and then we just dive into the class twos, because that's going to take some more significant time too.
Yeah, I like
Maybe
that.
maybe explore that. Yeah, see, we get the ball rolling on that. I know people are. I get hit up all the time. People are curious. Hey, wait, how are things going in that meeting? You guys aren't changing things too much, are you? We're like, yeah. Anyhow, but definitely appreciate this, and then we could. There was a couple of things I think you had recap, Captain, already in terms of deliverables, and we'll just pick this thing back up, same place, same time next week.
Okay.
Okay. Talk to you later.
Thanks, everyone.
Excellent. Have a good night, everyone. Thank you.